Today we'll be looking at the key governance and human rights concerns as we begin the year 2025. Now, human rights and governance issues remain at the top of the agenda of some key stakeholders who insist that there are issues that are continuing to emerge, that need to be addressed, not only for tranquility in our country, but also to ensure that the next elections in 2026 go well and to avoid any skirmishes that has happened in the past. So they are looking at issues around governance and human rights issues. So today we want to understand some of those issues that we need to follow closely and have them resolved in order to ensure that we have a country where all people and their rights are respected, but also where we have a governance situation that allows people to freely exercise their mandate, but also enjoy the country they are in. In studio, I have one of the historical, fighters for human rights in this country, but also somebody who also clearly follows issues of governance and has been working around them, and that's none other than Dr. Livingstone Sewanyana. He's a human rights and governance expert, founding executive director at the Foundation for Human Rights Initiative, key player in SEDU, and he is also a former UN independent expert on promotion of a democratic and equitable international order. Good evening, Dr. Sewanyana.
Good evening, Kenneth, and good evening, listeners.
Happy New Year.
Happy New Year, Kenneth, and Happy New Year to all our listeners this evening.
Right. When you talk about issues of governance and human rights in this country, your name is among the many, but also the few that emerged top on the list. And we've begun the year, but of course we had the whole year in 2024, where there were a number of issues, and some people had said some of them are likely to flow into the new year, and others said maybe they're in the past, we have dealt with them, they will never show up. Let's begin with your quick analysis of how the year ended in 2024 as far as governance and human rights is concerned, and then we see what you think we need to pay close attention to as we begin 2025, which so many people say is very critical in terms of the next elections we are going to have in this country.
Well, first of all, let me thank Radio 1 for its consistency, because I think this is not the first time we have been here. You have treaded a very, very clean path in advancing issues to do with human rights, democracy, but also what we call the common good. Having said that, to our listeners this evening, the issues that one would look at as we start the new year are very much the same issues that characterized the end of last year. So what we're actually having is what we call a trickle-down effect. They are just the same concerns that one would have had, but of course, being a pre-election year, 2025 being a pre-election year, we are likely to see, of course, an escalation. Some of these issues, escalation in terms of rights violations, but also, abuses, not necessarily based on reason, but sometimes based on fear. So, just take you back to 2024. We started seeing, of course, some behavior which spoke to a rather, dangerous pattern. One of the issues one would allude to as we came to the end of the year were some of those, some people call unresponsible, others call them all sorts of names, tweets by those, by those who are, I would say, well protected. There were concerns about partisanship within the army, where some individuals were being, alleged to engage in political debate, yet they are serving army officers. So that already spoke volumes in terms of what was to be expected. And this has, of course, if you notice, there have been more of this in the early part of 2025. Of course, as we speak, 2024.
Do you take those tweets seriously, Dr. Sawanyana?
You don't necessarily have to take them seriously, but of course, once they are in the public domain, they are a matter of concern. Because I mean, why would you make those tweets if you really don't mind what you are talking about? And who is actually issuing them? If it was me, maybe if it was Kenneth, that would be a different matter. Going back to the issues that still concern us is the question of access to justice. As you recall, we closed again with a very unfavorable prison situation. Prison congestion remains a big issue. Actually, just on Monday this year, the spokesperson of the Uganda Prison Service released the statistics. It is worrying. I mean, it's indicated that over 78,000 prisoners are in jail, and out of those, about 37,000 plus are pre-trial detainees, 40,000 convicts, which gives roughly a ratio of 47 to 53. 47% of our prison population right now are people who have not been tried. They have not been tried. We call them remandees. And of course, if you know very well, our constitution is very clear. There is a presumption of innocence. So if they are not tried, they are not convicted, then of course that causes a lot of concern. So that has spilled over to 2025. Other concerns, of course, are issues of economic nature. Poverty still prevails. It's on the increase. We still have a lot of youth who are unemployed. And of course, our economic performance is not the best. I'm yet to see statistics from Bank of Uganda, but I would be Minister of Finance. I'm yet to see how we perform. But as far as I recall, we had a debt burden of over 50% of our national budget. I don't know what the current standing is, but that also is a matter of serious concern. So again, I would say, of course, as we entered 2025, the political temperatures had started rising, and they are rising steadily. As you know very well, the Electoral Commission issued a roadmap. I'm informed that this week they will be giving us an update on the roadmap, but that creates a bit of concern. As you recall, we have seen some new party, I think the Democratic Alliance, is it the Democratic Alliance of Honorable Matthias Impuga has been established or was formed. We are also aware of PFF, is it PFF? PFF of Dr. Chiza Besigye and colleagues. And you recall that last year, some of their members were, in quote unquote, kidnapped from Kisumu and brought to Kampala, and that also raised concerns. And I think as we entered 2025, we still had the repeat where Dr. Besigye was also, quote unquote, abducted from Nairobi, and right now is facing trial. Again, that's a spillover from 2024 to 2025. So issues of justice, and we spoke out vehemently against trial of civilians in military courts. We were very much concerned about that. So you say spillover from 2024 to 2025. So there are concerns, there are issues, and we now see an exchange, though it's verbal sometimes, of some of the political players, in which are not really consistent with good political practice. So you can see that there are quite a number of concerns, issues that warrants attention from 2024 that have spilled over to 2025. And now as 2025 begins, I think on the very last day of 2024, we had again to utter shock in his address, the presidential address, President Museveni making a directive that he was banning police bond, and was concerned about grant of bail by the judiciary. All these are concerns that have spilled over to 2025, and they definitely merit serious consideration.
All right, let's begin from the bottom, because the two presidential address and the trial of civilians, things that are very new in the public domain. They are current affairs. Let's begin with the presidential address. The reason the president is banning police bond and also expressing concern about bail, one is saying police bond is being abused. People, especially in villages, who are stealing and doing all sorts of things, are being given police bond, and they keep on doing the same things they have been doing, notably disturbing wealth creators. That's what he says, including harvesting coffee that is not yet ready. And of course, the issue of bail. They're releasing criminals back within the communities just because they are being granted bail. How do we strike a balance there? Because the president says he has the power to make a directive to stop police bond.
Of course, one needs to understand where he's coming from. He's very much concerned about stability. He's concerned about crime, how to deal with crime. But I also think he's also mindful of 2026. Whatever directive he gave, I think, has to be seen in that context. Now, on the question of police bond, of course, to a common person, an ordinary person who may not understand what police bond is, it is something that maybe he or she may not be concerned about, or may welcome it naively, if I could say. But for you to understand the importance of police bond, you need to consider a couple of things. One, you need to be mindful that in an ideal situation, arrests should take place after investigations have been completed, which means that the police ordinarily would have to investigate, get evidence, charge a person, and bring him before a magistrate. Now, the challenge is that in Uganda, the police is yet to gain that capacity, that ability to investigate, gather the evidence, and bring a matter before court. And the Constitution is very clear. It provides for 48 hours within which a person must be brought to court. Now, to understand the importance of a police bond, then you have to look at it in that context. One, the police officer has a duty to bring a suspect before trial, or before a trial judge or magistrate within 48 hours, but he also has a duty to ensure that he has adequate evidence to back up his charge. Now, in the circumstances, Parliament or the law makes provision that in selected cases where the police officer feels that in such a case I really need to investigate first, get evidence, at least let me give this person a benefit of doubt by invoking the presumption of innocence and ensuring that this person has some room, instead of holding him in a police station, although of course we also are aware that police stations are full. Now, if you remove that power of police officer granting police bond, what that naturally means is that every person who is arrested should be brought to a magistrate within 48 hours, irrespective of what evidence you have, and that means that that person has naturally to end in prison. Now, already we also know, I started by telling you, one of the challenges we face in this country as we come into 2025 is that the prisons are already overcrowded. You have a 47% pre-trial detention ratio, which therefore means you are going to make the situation even more complicated. Now, that is the reason why many of us are convinced that that directive was misdirected or ill-informed. But besides that, you need to be aware that police bond is not a creature of a presidential directive. Police bond is a creature of the law. It is provided for in the Police Act, which means that Parliament made law to provide for police bond to deal with the situations I've talked about. Now, in a normal process, other than ruling by decree, it requires the executive, which is of course headed by the president, to bring a bill before Parliament, raising all his concerns as he did, and it is debated, and once passed, he has the power to assent to that law. Now, dealing with a matter provided already by law through a presidential directive in itself amounts to a misapplication of the powers that be. So again, you can see that the directive is ill-conceived, and I think rightly, whether we agree with him or not, our concern is also the manner in which the matter is raised. So he should have actually invoked the right procedure for him to attain his objective. Now, on the question of bail, he has been very consistent. This is not the first time he has always opposed the grant of bail. Of course, maybe one other last thing I should also point out, that rather than objecting to grant of police bond, he should also concern himself more on allegations of corruption within the ranks. Because what causes that, and why, from what you said, that someone is given a police bond and then finds himself in the community and of course creates further havoc, sometimes is perpetuated by misdeeds of the powers that be. So he needs to address that a bit more. But there is also another element sometimes, and I think I'll speak to that when I'm dealing with the issue of bail. Now, talking about bail, bail is a right that has been conferred to us under Article 28 of the Constitution, warranting what we call a right to fair trial. Now, bail is not granted to everyone. One, bail is only granted on condition that you have satisfied the requirements for bail. And the magistrate or trial judge, or the case may be, often has to convince himself or herself that one, you'll be able to report; two, that this matter will continue to be tried without having any undue influence. And if that is the case, then definitely one should not worry. And even in the case of police bond, or in the case of bail, there is also a requirement to report. So it doesn't amount to an acquittal that once one has been given police bond or has been granted bail, he or she has been acquitted of the offense. Actually, the trial continues or the hearing continues. So all the investigations continue. So I don't see why one should be so much alarmed by the fact that police bond is given or court bail is granted. So I think it is important for us always to be mindful that these safeguards are granted for the sole purpose of ensuring that there is no travesty of justice. That to me, they are minimum guarantees that my rights will not be abused in this situation. Because not everyone who is arrested, ideally, is actually a criminal or has committed a crime. Sometimes arrests are perpetrated or perpetuated through rivalry, business rivalry, social family rivalry, and subjecting a person to detention either before police station or in prison in itself is unfair. So I think those minimum guarantees should be protected if we are really thinking about a fair trial. And as such, we find, and I find myself, I think that those presidential directives were not only ill-advised, misconceived, but I think uncalled for.
But and then how would you advise the president? Because like you said, he seems to be concerned about fighting crime. What do we do in order to deal with these issues?
I think you strengthen the systems. If the president wants really to have a sort of a crime-free society, or a relatively crime-free society, then we need to strengthen the systems. I mean, if you look at the police, look at the Department of Investigations, they are ill-resourced. The institution is ill-resourced. Because the ideal, as I said at the very beginning, is that investigations should take place and then arrests should then follow. Of course, there are certain offenses, or there are cases where you definitely cannot just allow a serial killer, to remain in society, or call him a serial thief to remain in society. There are cases where one would not even argue or would not even advocate for police bond or advocate for bail. There are outright cases one would say, no, you wouldn't do that. But there are also cases where you find, for example, you are a law-abiding citizen, Kenneth, or my listener out there, and someone has made an accusation. You have no criminal record. You are somebody of substance. An accusation has been made. Why shouldn't we have some time to investigate this matter, have the evidence before before sending this person to prison? It's just unfair and uncalled for. Then, of course, what they call pet thieves, they call them village thieves. Sometimes some of those descriptions are a bit misleading. Who is a village thief? Because a thief is a thief, whether he's in the capital city or he's in the village. What is important is that due process must take place. So it doesn't really matter who the suspect we're talking about here is. What is important is that the safeguards must be in place, due process must take place, and as such, in the process, you ensure you ensure stability. The other one is to follow the right procedure. That's the other thing I said, and I alluded to earlier. That yes, he has the power. He's the executive. He's the head of the executive, and as you said, he controls the police. Agreed. And no one disputes that. What is important is for the procedure. If you feel that police bond is not warranted and it's no longer appropriate to grant police bond, then you initiate a bill, and the bill is brought before Parliament, and of course it is debated, and of course if you have the majority, you have the day, and the law is passed. Of course, if we don't agree with it and we feel that human rights guarantees are being abused, we shall contest it in a constitutional court. And if the constitutional court agrees with us, it would then be declared null and void. But overall, procedure is important, process is important, but at the same time, strengthen the institutions. And I'm glad that the president has been working hard to strengthen the judiciary in some respect. As you know, ever since they passed the Judicial Administration Act, if you remember, Kenneth and our listeners, more funding has been given to the judiciary, more judicial officers are being recruited, and more courts are being opened, which therefore means that if the other prosecutorial arm is also strengthened, then it would be possible to have investigations completed, evidence gathered, and we would actually not need even now police bond, or wouldn't even need bail. Right. So you strengthen the systems, there's a free flow of information, and as such, you still protect the rights of the accused without necessarily unfairly harming his interests.
All right, Spectrum on Radio 1 FM 90. Keep your comments coming via the WhatsApp line 0703 090 090. Let's go for a break now. When we return, we'll look at the issue of the trial of civilians in military courts. There were things that happened yesterday in court, and one of the lawyers ended up being, sentenced to 9 months in jail. That is Aaron Kiza. And we'll be looking at that. Should trial of civilians continue in military courts? Dr. Livingston Sowanyana will be sharing his perspective on that particular issue. Stay tuned to Radio 1 FM 90. We continue after this break. Well, thank you so much for staying with us on Spectrum, live on Radio 1 FM 90. My guest this evening is Dr. Livingston Sowanyana, human rights and governance expert, founding executive director at the Foundation for Human Rights Initiative, and not long ago he served as the UN independent expert on promotion of a democratic and equitable international order. Our topic of discussion, we're looking at the key governance and human rights concerns in the year 2025. Keep your comments coming via the WhatsApp line 0703 090 Dr. Living Sawanyana, you hinted on the issue of the trial of civilians in the military courts. And this issue has come out again because of the ongoing trial of Dr. Kiza Besije. Yesterday, there were issues that happened in court. The trial has been, adjourned to Monday next week. Your quick take on this debate. Shouldn't the army continue, trying people who are found in possession of what they think is under their control in their respective courts?
This issue of trying civilians before military courts has been of great concern to human rights defenders, but also has been an issue of discussion for quite some time. As you recall, this matter is not new. Some time back, this matter came up before the Constitutional Court, whether civilians should be tried in military courts. And the Constitutional Court ruled that it is unconstitutional to try civilians in military courts. And the thinking is simple. When you think about a military court, it has less appetite. It has very little appetite to humane treatment of civilians. Secondly, if you think about a military court, it is best designed to enforce discipline within the military. And as such, it is best placed to deal with the military, because the military, they are expected to conform to certain behavior, and ensuring discipline is key to ensuring that they carry out their work and in an orderly manner. And sometimes there is credit to that, because the military, if it is, of course, not contained, it can actually be a source of disaster. And we know that, going by our history. So military courts have been established for the very sole purpose of instilling discipline and ensuring that soldiers act in accordance with the military code. Now, when it comes to civilians, civilians by their very nature, they very much appreciate what due process is, that you take them through the rigors of the legal process. And sometimes it's also, I think it is also discomforting for a civilian to be in a military court. Not that, of course, civilians don't find it discomforting to be in a civilian court, because civilians also fear ordinary courts. You know that. I have interfaced with many people who find it very difficult to go to a court. They would even tremble and would lose sleep. Just imagine how much sleep you would lose if you actually told that you are going as a civilian to be tried in a military court. So I think the two institutions should be distinct and operate separately. Now that the Constitutional Court ruled, of course, we are aware that the Attorney General appealed, and this matter is before the Supreme Court. Now, notwithstanding the appeal, we think it's not proper for any person who is a civilian, just because you have maybe military attire. And what constitutes military attire? Other than if you had guns, if they found you with the guns, I would understand that. But then the other challenge going to our practice now is the inconsistency. If you recall, our listeners out there have been cases where matters which ordinarily you would think would have been taken to court martial are taken to a civilian court. Do you remember the Nakawa bombings? Where were they tried? They were tried in a civilian court. Why? Why not in the court martial? There are inconsistencies in these trial processes. So, which means that besides the discomfort I have talked about and the illegality, I think there are also political considerations. Why should, in some cases, find certain you remember the NUP suspects? Where were they tried? They were tried in a military court, isn't it? Again, we are dealing with civilians, and yet you have so-called terrorists being tried in a civilian court, yet they could have been tried in the court martial. So there are also inconsistencies in this practice, and as such, we think that the best approach would be that if you are a civilian, as far as I know, Besigye is no longer in the military. He retired. He retired, and therefore should not be considered a military officer to be tried in a military court. And of course, what we are witnessing now also speaks volumes to this fear. For example, the fact that Aaron, a lawyer, was arbitrarily and summarily sentenced to nine months prison, again raises concerns. Where is the right to be heard? He completely is not heard. His sentence, is that due process? There's no due process. So the behavior that we see in a military court or a court martial is alien to civilians, and as such, we hope that one of these days the Supreme Court will rule on this matter and let it rest.
All right. So do you think these courts should be scrapped? Should they specifically focus on the army? Or what would you advise in that?
No, the court martial has to,
because the army insists that, look, the law is clear. If you're found with what belongs to the army, you can be taken to their court.
But what belongs to them? Because you need also to be cautious.
Guns, ammunition.
Yeah, but if, for example, if you are dealing with a rebel, I would understand someone trying to fight the government. But if you are dealing with somebody chanting anti-government slogans, and you bring that person before a court martial, what actually there belongs to the military? Or if I ask you, if you put on a red cap, like these people of NUP,
red beret,
or red belly, of what military significance is that? I see if you travel, you find people putting all sorts of military wear, ordinary citizens. Some use it even for artistic work. Haven't you been to some of the? And we are told they have to be cleared first. You get clearance to use them. Clearance? How sure are you that these people do not actually have clearance? The bottom line is, let's stick to the right path. If I am a military person, I'm a soldier. All I'm engaging against the government, for example, like rebels do. That is a good fit for the court martial. But any ordinary citizen, just having military apparel or just not in good terms with the powers that be, that shouldn't be a justification to be brought before a military court. All right. Let's look at the 2026 general elections. After the 2021 general elections, there were issues which were documented and some advice even given on the possibility of reforming the laws, strengthening the system to ensure that we have a free and fair process that would actually bring out results that are accepted by all. What is your take as we prepare for these elections? Are you happy? Have we done enough to ensure that what has been happening in the past does not happen again? I think speaking about the 2026 elections, one gets really concerned as the extent to which the ground has been prepared for citizens to actively participate. You remember when we had SEDU, when we had the Citizens Coalition for Electoral Democracy in Uganda, there were a lot of civic education campaigns, and there were a lot of awareness. There was a lot of mobilization. But of course, I'm yet to see any efforts at mobilization or civic education for the citizens as we prepare for 2026. We should be asking you. You're the ones who are in charge of SEDU. Yeah, I mean, SEDU ceased to operate because its permit was never issued, was never renewed. As you recall, again, it is in the powers of the state to allow it to operate or not to operate. And when the 1-year certificate, you remember that SEDU was under FHRI for 10 years, and it operated effectively. And there was a movement, a very strong call to have it registered and operate independently. And when it was again registered, given a certificate, normally it's 1 year permit. Efforts to renew the permit became quite problematic, and it could not continue to operate. So, as you recall, in 2021 elections, said was an operational.
So lack of civic education.
So lack of civic education is a concern, because people need to be mobilized. People need, people need to constantly be, empowered about the necessity to vote. By the way, people come of age. You recall that by 2021, there's quite significant part of our population who may not have voted in the 2021, and they come of age in 2026. They need to understand why one would vote, what are the considerations, what's the importance of, electing your leaders. So civic education is critical. Mobilization too. You remember we had those campaigns called Topowa. They don't give up. Of course, you know that...
Honor your vote.
Yeah, you know very well that there are people who are always adamant about elections, especially the elite. And now you need also to constantly, drum it up that it's important for them to be active participants, that they should participate and partake in their country's governance. So when you don't have those mobilization efforts, then definitely you're raising a serious issue. Then there are also need for electoral reforms, electoral and political reforms. Those issues were raised over and over, and in the 2016, I think, election dispute between Amama Mbabazi and President Museveni, the Supreme Court came out very clearly on areas and issues that need to be addressed if we are to have free and fair elections. I'm not aware of any significant reforms that have taken form, and as we prepare, we also need to look at that. To what extent does IT play in an election? To what extent should, for example, the media be guaranteed free space during an election? What's the role of the different players, the military or the law enforcement agencies, the citizen, the candidates agents? The question of DR forms, you remember, has always been another concern. Electronic transmission of information. There are very many issues that merit consideration before one really has an election. I hope, as the Electoral Commission gives its update this week, it will also speak to some of these concerns, because ideally, if that doesn't happen, then the likelihood of Ugandans not coming out in large numbers to vote becomes so high. And yet, for any serious national electoral process, there is need for massive turnout of voters. So again, it speaks sometimes to the fact that much as these issues have been raised, there's very little action in terms of addressing them in order to create a political terrain that is conducive to all. So again, I am concerned that those issues, despite the fact that they were raised in 2016, now we are talking about 2026, which is almost 9 years or so, we are yet to address them. And of course, I'm concerned. For example, you know very well, in the 2021 elections, internet was shut down.
Up to now, we to access Facebook, you must use VPN.
Exactly. So what's going to happen? Are we going to have a replay of the same scenario? So these are things that one needs to really think about, address, and create that fertile ground within which people then say, oh yes, the election serves a purpose, the election is here, and we need to cast our vote, and we make choices of leaders that we deserve.
So in other words, what you're saying, that we are going to have the same things that we had in the past happening again in 2026.
I see a replay in very many ways, because we are just about a year to go.
Mm.
I'm just wondering how much civic and voter education you can give now. I'm wondering whether these bills are now before the House. The electoral reform bills are before the House. I understand Honorable Mpuga has been driving
Made
up
some
these
proposals.
issues.
Yeah,
I don't
but
know where
he's
they are,
yet
at
to be
what
given
stage,
space.
because I expect the Minister of Justice to come up with these, bills, speaking to the reforms that are necessary. So again, there should also be a time frame within which some of these actions are brought up. So I'm just hopeful that the Electoral Commission, in its conventional wisdom, will be able to address some of these issues, and try to allay fears of many people who feel that maybe little is being done to address the anomalies.
All right. Dr. Sawanyana, let's get some response from the listeners who have been following this discussion. And I'll begin with Okello Patrick Bonyo, who's listening in from Busega, who says human rights in Uganda or countries which are less developed are never considered as necessary despite wide bodies like UN pronouncements against human rights violations. It's difficult for a civilian lawyer to stand and argue a case before the military men because for them they deal with orders. How did the military court come to exist? What was it to cure? What was it supposed to cure where the civilian court was not delivering? Shall we continue to have it trying civilians? He says, Happy New Year to those in studio. We have a comment coming in from Businje who says, armed robbers are always tried in civilian courts, yet they are suspected to be using military equipment. We have a comment coming in from Caroline Kalanzi, who is listening in from Boston in the US. He says, Doctor, what's your take on how constitutionalism is being observed in Uganda in relation to human rights in general? And then we have David writing and said, can Dr. Sawanyana give us a distinction between a person of substance and a person of no substance from a perspective of international human rights conventions and constitutional provisions in Uganda? Then we have another point. Good evening. If the tribunal is to be recognized, at least let the chairman be a lawyer with the equivalent of a judge. That's a comment from Businje. Then we have another comment. Thanks for the show. I think the sensitivity and the degree of a case matters a lot. For example, someone stole our 2 million. We took him to the police. Evidence was gathered, but he was later given bail. Up to now, his whereabouts are unknown. Yet we want the police not to release him. So that was police bond, I think. So let's be considerate when we are defending thieves. Mr. Sawanyana, that's why mob justice is rampant, and we shall get him and kill him because we failed to get justice. That is Nsubuga Shafik listening in. Then we have another comment. Good evening, Spectrum. Ejoy Job Arwa Boy listening in from Rubaga. Concerning the police bond, Mr. President should look at Uganda as a nation, not a family matter, where if the father says everyone should go to the garden, you have to as a child. Where are the ministers who stole Mabati if he's serious about fighting crime? Well, those are some of the comments that are coming in from the listeners. Very quickly, if you can respond to some of them.
First of all, I want to thank our listeners. I'm happy that you have been following, and I think you have made very pertinent remarks. I definitely appreciate your viewpoints. For many of them, they are just, I think, reinforcing the arguments I've made. Maybe for one of the callers who is concerned about police bond and the fact that thieves are released to the community, I can only say that that is a failure of the system, because if the system is reinforced, it should be able to detect those who definitely don't deserve a police bond. But having a blanket ban in itself, I think, is prejudicial to stability, but also to fairness and justice. As to who is a person of substance and not a person of substance, I want to invite the listener to always, I think, fall back to intuition, imagination, but also I would say to practice and observation. Because who a person of substance is known as a person who has credentials, someone who is consistent, someone who speaks to the what we call the common good. just this morning, I was having a meeting with my team, and we are very keen. We are interested in this recent. There is a clip. I think Kenneth, you have seen it, where they describe the three types of people in society, where they talk about who is an idiot, who is a tribalist, and who is a citizen. I love that Greek mythology of who is who, and as such, a person of substance could be linked to, to a citizen. A citizen is someone who very much advocates for the common good and sacrifices for the common good, works for the common good, and actually is interested in the prosperity of all. So I would argue that person of substance should be a citizen.
All right, we have a comment that came in from Caroline Kalanzi in Boston. She wants to know your take on constitutionalism and how it's being observed in Uganda. Are you happy with what is happening?
I think we still have serious challenges with the application of the Constitution. You said Caroline? Caroline. Yeah, we have serious concerns because we believe we have a fairly progressive Constitution, which unfortunately seems to be watered down increasingly every day, as we don't seem to practice it the way it was envisaged. You know very well, on many occasions, this Constitution has been undermined. You recall, for example, on the question of the age limit, on the issue of the term limit. You are aware of the decentralization against centralization. Now we are even talking about police bond and the right to bail. All these, to a large extent, speak to a fairly poor record, and as such, the need for us to pull up our socks and ensure that the rights enshrined in the Constitution are actually respected and upheld.
All right. I want us to end the discussion with the issue of the economic and social rights that you raised. You talked about poverty and unemployment. You even talked about the debt burden. Why are you concerned about some of these issues, Dr. Swanyan?
Oh, increasingly.
And as the year ended, you saw the president actually stepping up the poverty alleviation campaign, wealth creation.
Yeah, I think increasingly one needs to appreciate that rights are indivisible, that the rights we talk about are not only civil and political rights, they're economic, social, and cultural rights. And unless you deal decisively with economic, social, and cultural rights, it's also sometimes very difficult to create a class of society that actually can withstand authoritarianism and bad practice. So it is important that if you are to enjoy your rights, you also have economic power. And of course, you know very well, in societies that have been able to resist oppression, they are wealthier, they are more economically empowered, and they have increasingly been able to address the challenges of poverty as well as other social malaise. And when speaking about social malaise, you very well know that there is a strong connection between having a voice and the ability to participate and economic power. When you have economic power, your voices can easily be heard and respected. You can make choices. You are able to resist unfriendly decisions, and as such, you can withstand oppression. When a person is poor, he has no choice, he has no voice, he's more or less concerned about survival, and rights definitely do not mean much because they are at the periphery of his survival. And as such, those who have power find it very easy not only to exploit but also to subjugate that individual in a manner that sometimes does not meet the right standards. So as such, there's a strong connection between economic empowerment, political empowerment, and dignity of the individual. And it is important, therefore, if we are going to promote human rights, to ensure that as more people and more more people get economically empowered. Of course, the programs that you speak about of economic empowerment, that the program continues, that the president continues to churn out, they are important. But also they must address the critical element that for them to make the desired impact, they must reach the poorest of the poor. And if the poorest of the poor do not benefit from such, then of course they continue to create what you call the status quo, that still the rich become richer, the poor become poorer, and more people get marginalized and disenfranchised, and increasingly become despondent, and therefore withdrawn and disconnected from the state. And once there is a disconnection between the citizen and the state, then what actually brings them together is always force and rhetoric.
I must thank you, Dr. Livingstone Sewanyana, for sparing time to speak with us this evening. Thank you so much.
Always a pleasure to be on Radio 1, and thank you so much for the opportunity.
Thank you so much, dear listeners, for tuning in and contributing to this discussion. I've been your host, Kenneth Anderson Lukwago. Up next, we have the news in English with Miss Josephine Dakano. Thereafter, we'll have the Soul Train with BP Junior.